Telus versus Harvey de Guzman. De Guzman was hired as a call center agent of Telus, who later became a senior quality analyst, QA, for Dell account. A complaint was filed against him by Telus and Flores, a team captain, for disrespect and ridicule towards a person. The escalation complaint alleged that Flores, during an avail, sent a chat message to QAs directing them to do coaching. She messaged, "QAs, there are tons of avails. Do your coaching." Harvey, who was among the QAs who received the message, replied, "That is good. You can now do your huddle for your team." Flores was offended when the other QAs exited the conversation, and by de Guzman's reply, as she felt that he was implying that she has no time for her team. Later on, she chanced upon the IP switch conversation between de Guzman and a fellow agent, Rally Boy, wherein de Guzman made disrespectful remarks against her. The conversation goes this way. rallyboy.sci@chat.ambergris.prv, Rallyboy. Guys, Rallyboy. Dami avail, Rallyboy. Do your coaching Harvey de Guzman, QAAEE, and a 10th Raffles QA Lab X 3580, Harvey de Guzman. That is good, Harvey de Guzman. You can now do a huddle for your team, Harvey de Guzman. Ha ha ha, Rallyboy. Ha ha ha, Rallyboy. Sabihin ko nalang avail you face Harvey de Guzman. Ha ha ha, Rallyboy. May upload pia kami, Harvey de Guzman. Wait lang, Rallyboy. Tangina, agugulpihin ko talaga yan, Harvey de Guzman. Di pa makagawa si Nino. Acting on the complaint of Flores, Telus issued a due process form to de Guzman on charges of insulting or showing discourtesy, disrespect, or arrogance towards superiors or co-team members, and abusive behavior language, which is outside the bounds of morality, in violation Telus's code of conduct. Later, de Guzman received an incident report and was informed that he was placed on indefinite preventive suspension effective immediately. Feeling aggrieved, de Guzman filed a complaint before the Department of Labor and Employment, DOLE, for illegal suspension. Amicable settlement failed. However, after the termination of the proceedings in the DOLE, de Guzman received a text message telling him to report to know the status of his preventive suspension. De Guzman, together with Rally Boy, went to the management's office. Thereat, they were told that their suspension was lifted and that they were not liable for the incident that transpired. Nonetheless, they will be transferred to a different account, and they were to report the next day in Market, BGC branch. Thinking that everything was in order, they eagerly reported to their night shift schedule in Market. They waited, as per advise. However, at around 1 o'clock in the morning, they received a text message asking them to report to Ortigas' office instead. Despite the inconvenience, they left Market and went to the Ortigas' office. Thereat, they were told that there was a mistake in instructing them to report for work, and that they would still need to find an account for them. Hence, they did not have any work yet, despite the lifting of their suspension. De Guzman was then forced to apply for a vacation leave and exhausted his earned vacation leaves and used up 26 days. After all his vacation leaves were spent, and a month after his preventive suspension, de Guzman inquired when he can report for work. He was told that there was no endorsement yet for another program and was considered as a floater, and he will not get paid unless his floating status has been lifted. De Guzman received a message that he should report for a profiling interview and that it was necessary to pass the same in order for him to get the position. De Guzman asked why he needed to undergo such interview, considering that he was not a new hire or a job applicant. They responded that passing the interview is a must, as he was already considered a floater. De Guzman filed a complaint before the NLRC for constructive dismissal, money claims, and damages against Telus. Issue 1. Whether or not de Guzman was constructively dismissed by Telus. 2. Whether or not putting an employee in a floating status is valid. Ruling, yes. The Supreme Court held that constructive dismissal exists where there is cessation of work, because continued employment is rendered impossible, unreasonable, or unlikely, as an offer involving a demotion in rank or a diminution in pay and other benefits. The series of actions done by Telus manifests that de Guzman was terminated in disguise, and such actions amount to constructive dismissal. The conclusion is all too clear that Telus fostered a working environment that was hostile, discriminatory, unreasonable, and inequitable that naturally compelled de Guzman to give up his employment thereat, to avoid the difficulties he had to face just to keep his employment. The Supreme Court further ruled that it is not correct for Telus to place de Guzman on floating status. Contrary to the stance of Telus, the floating status principle does not find application in this case. While it may be argued that the nature of the call center business is such that it is subject to seasonal peaks and troughs because of client pullouts, changes in clients' requirements and demands, and a myriad other factors, Still, the necessity to transfer de Guzman to another practice account does not depend on Telus's third-party client/contracts. When the controversy arose, Telus had several clients in its roster to which it can easily assign de Guzman as quality analyst without any hindrance, and the company had several job vacancy postings for the position of quality analysts. While there is no specific provision in the labor code which governs the floating status or temporary off detail of workers employed by agencies, it is implicitly recognized in Article 301 of the Labor Code, which speaks of situations of temporary retrenchment or layoff due to valid operation issues. In this case, Telus did not provide any valid justification or presented proof that there was indeed a deficit of account that bars the immediate transfer of de Guzman, or that the company was sustaining losses that would justify placing de Guzman on floating status. Hence, the unwarranted acts of Telus evidently constitute proof of the constructive dismissal of de Guzman.